I'm with Nick Cornu, who will be quite well known locally, who has for a number of years been representing people, or assisting people in some cases, before employment tribunals, and sometimes different aspects of the tribunal service, because they need representation. How long have you been doing it, Nick?
About 5 years. I'm an English qualified solicitor, but it came out of really states work when I was a deputy because people wanted assistance on employment matters. I helped one deputy on a case he had because I had legal skills, and that sort of made me aware of it. I'm hoping that people stick with listening to this video because I hope it's an introduction to your rights as employees in the employment tribunal, and you get something out of it. It's a little guide because there isn't anything really to assist you. It's to give you a bit of insight into the way things really work rather than what you might be told by others about what your rights are, because
it's interesting
all the same.
You say you started when you were a deputy, because in fact I've attended many of these tribunals and social security ones. Very seldom do I see a states member representing anybody. They don't seem to fall into that. It doesn't seem to be on their radar, does it?
I've seen one states member. Yeah.
Is that
in the tribunal, actually,
right,
with the client, if you like?
Which is sad, really, because I think a lot of them would be, from listening to you and from other cases which I've heard, the vast majority of states members wouldn't have a clue how to represent anybody because they simply do not know the law in detail.
No, that's
and
correct.
It's a learning process. Over 5 years, your knowledge presumably has increased considerably.
Absolutely, very much so. And I hope I'm on a par with some of the advocates. They may not agree.
Well,
but I think in some ways I'm a little more alert than they are.
Their hostility is one of the aspects we might, if we've got time, discuss. I mean, even the chair and the panel that hear these things, I presume, I've noticed that they've become more learned, haven't they? So they tended to come. But I noticed the other day you were doing a case and you were having to sort of just gently nudge the chair into following procedures, swearing the person, a witness, they have to swear the oath, and you say, well, they ought to swear the oath, so to swear their witness. The chair wasn't really on the ball. I mean, little things may not matter, but if you have a hearing and the witnesses, for example...
Well, there has been a change of regime. I don't know what's gone on, but in the background, but there are certainly a new chairman of the tribunal. There are some new judges. Things weren't as they should have been.
Right.
And one of the good things that's returned, hopefully, is the fact that they're going to produce judgments within 6 weeks of the hearing. I, in one case, had to wait 6 months.
6 months, which is not satisfactory.
It's not acceptable.
Well, for the person who's aggrieved, presumably, if they were out of work,
Those are the kind of delays that some people faced. Now they'll get much more swift justice, which is what it should be.
What are people supposed to be? Because there's no legal aid. What are people supposed to do?
Yeah, there is no legal aid. Maybe if you're a member of a trade union, you might get some support through their associated advocates. I've only seen that occasionally. Most occasion people are unrepresented and they're trying to get through it themselves, and it's extremely difficult. Sometimes people have enough money, particularly if they've got finance jobs, they can employ advocates to represent them, and no doubt it's costing them a lot of money, but they may need to do so perhaps because they're protecting their reputation in the finance industry, which could collapse if certain things were said against them.
If a person tries to represent themselves, an ordinary litigant, if they're aware of the tribunals, that's one thing, they've got to be aware of it. I suppose most people have heard of JACs, and people tend to get referred to JACs. Maybe, but not always. Obviously there's a lot of people every week, quite a lot of people are dismissed from jobs for whatever reason, or they don't know their rights. How do they find appropriate advice? How do they find it, in your experience?
It's quite hard because they'll get told one thing by one advisor and something else by another advisor, and often for I mean, I sympathise with Jacks when they've only got half an hour with someone
Right.
to try and pull out all the detail, and often the employee doesn't understand or can't communicate the most vital element, which they just don't think is important, and then suddenly they tell you, and it's like something drops from heaven. As an advisor, in half an hour, that's really difficult to pull out all the facts and then advise.
I noticed a case recently where you advised one of your litigants that if you asked, they said to them, did they have any private insurance of their own? In other words, household insurance, because sometimes these insurances include for legal representation, and in that case, they did.
Yes, that's right. I represented the client, and then the question was asked, do you have any other household insurance? In which, sure enough, the person did, and associated with it was a policy from Direct Line Group. I recommend it. It's only £15 a year, apparently. That provided something like £20,000 worth of costs for counsel, and was absolutely a wonderful, real godsend to have discovered that. And many people may have that as part of their household insurance. If they've got it, they can then use it to assist them and bring claims. They could probably approach a firm of advocates. The cover may or may not be enough, because Jersey advocates are the fluffy bunnies, and of course they have to be well paid and well remunerated, and they charge a lot more than you would do if you were in Leeds.
Now, obviously, there's the complication of COVID, but in that particular instance, they recommended a UK barrister that you should consult, I believe.
Yeah,
So,
yeah.
and you were able to instruct that UK barrister. Did he appear, or was he on virtual?
Well, yeah, he appeared. He was
appeared.
representing the client as well. The client had two representatives.
Right, the client
and
had two. Right.
The respondent wasn't too happy with that. He felt
Indeed not.
outgunned.
As a result of that UK expertise, because they're used to these things, tribunals, that particular guy does a lot of tribunals. In Jersey he does some, but he's certainly in the UK, his experience, able to use that experience and to the benefit of your Jersey-based client.
Indeed, it was a highly experienced UK employment law barrister who was able to deploy his skills and advocacy and his knowledge, and really won the case.
Right.
Absolutely, it was.
And a substantial award for the claimant.
Indeed, absolutely.
Which you would say, I mean, let's be honest about it. If it was left to yourself, would you have got that award?
No, because the degree of resistance from the other side was so significant that I would have had difficulty pushing back against that.
Right.
But the counsel, the UK barrister, had gravitas, had experience. He wasn't having any nonsense, and he was able to push back much harder than I would have done.
I mean, I've mentioned to you before, I've attended many hearings, and I attended a hearing one day where there was a big firm over here. They were a UK firm, and they were in dispute with a client, with one of their employees, and the firm brought in a UK specialist barrister to argue their case, defend it, and the person was on their own. And that barrister they brought in was obviously used to aggressive tribunals, and the tribunal here chairman said, look, or the chairwoman, I think it was, chairman, said, look, there's no need to be so aggressive. We're having, we're trying to do this amicably. We're trying to have and he was. That's the sort of level. So lawyers have got to argue for their client, haven't they? I felt rather sorry for the client, the employee or the ex-employee, that she was being intimidated. But on the other hand, you've got to have somebody who's prepared to fight your corner, haven't you?
Because it is very much about a body of unique law, of knowledge, and it becomes and can become very rapidly very detailed and technical, and you have to know your stuff.
And it's changing,
that's
of
where
course.
the litigant in person is really handicapped. And if you can get representation, fantastic, by whatever means. But in Jersey, it's too expensive. Very few people can afford to pay advocates. There's no legal aid. Jack's does its bit, but it doesn't step outside its door. It's not going to represent you in the tribunal.
Language is a noticeable problem. If you're English speaking and you're handed a contract, it's quite difficult to understand the contract. And it'll say, sign here, so you've received the contract when you start a job. And it'll also say, sign here that you've seen the handbook. Maybe people sign it. But whether they read it, I doubt if many people read the handbook. And certainly they don't read the revised versions of handbooks that come up. So all these issues, when it comes to the tribunal, the lawyers for the employer will say, but this is what it says in the contract. This is what it says in the handbook. Didn't you read it? As though it's the litigant in person. How on earth did they know?
Yeah, there's two different worlds. There's the world of finance, where the employees are actually well educated and capable of doing administrative tasks, and therefore can run a case in the employment tribunal on their own. And I've seen that done very successfully. But on the other hand, hospitality is a very brutal place, and its employees, particularly if they're immigrants, have the handicap of language and the absence of connections and knowing where to go, what their rights are. They come from a background where bullying is commonplace, and they don't know where to turn. They have nowhere to go.
I noticed again, if the people are not English speaking, if it's not for a first language, if they've recently arrived and they take a job, which lots of these people have, they take a job, and if it lasts a while, their circumstances change. They've got all the usual things. But I noticed the other day there was an interpreter attending to interpret for him, and one of the lawyer for the employer kept on saying they were using the word. What were they? Respondent. Did you not understand the or something? Respondent. And I thought to myself that what they meant was Fred's Fish and Chip Shop or something. Whatever the employer was, that's what they would say in normal language. How would that person know what the respondent was?
I was there, and that was an advocate for the respondent who needs to learn how better to present their case.
Yeah, but it runs throughout. Anybody who picks up a contract, even if you are English speaking and try to understand, and when they talk about payment for holidays and
these
are incredibly difficult to work out.
They are, and there is advice available. Jax hopefully will assist and try and analyse this. But when it comes to actually arguing it oneself as a litigant in person, it's going to be quite tough, because if you've got a lawyer on the other side, then they're going to take you to task. And
of course, the reasons why it comes to be a dispute, obviously, the current COVID thing is lots of people were sacked effectively because of COVID, because the firms were fearful they wouldn't be able to carry on. It's quite true, and some of them got government assistance to carry on, but lots of employees suddenly found themselves with no real income, and they have to spend themselves.
Well, we had one case, one of the biggest employers in hospitality had effectively 330 people mass redundancy.
Right.
Out of 430.
And what was
employees.
Extraordinary to me, because I listened to most of that case, I didn't hear it all. They had no human resources department. So who do people go to where whilst you're working for a firm, little things come up, you want to consult with somebody who you hope will give you some impartial advice.
It's quite amazing that an organisation with about 400 plus staff doesn't have an HR department. And the reason is, off the record, it's that they'd rather sort problems as they arise rather than pay the staff to man an HR department, but I suspect that may be changing after certain litigation.
Well, yes, because I think they said it, like on the contract, it said in English, the guy, presumably, I forget, was a man or a woman, you sign the contract, yes, because you desperately want the work. If you want an English translation, you have a translation in your own language, you can ask. Well, I doubt if the person would even understand that was written in English. You go away, sign a contract and consult your lawyer. You haven't got a lawyer.
Well, they're desperate for the works that they...
That's right.
They know what the contract is and they sign it, but they don't know the details of it.
That's right.
They know they get paid, and that's what it's all about.
And the handbook itself, because they change, they modify. The handbook modifies according to changes in the law and also case precedents that the likes of you are bringing. So they get a nudge, we can't carry on like that. So handbooks all over the island will be modified from time to time, but the staff won't necessarily see them.
With handbooks, the correct procedure is, of course, that the new version is introduced. Every employee is sent one by email. We've all got emails, and in finance, certainly they will come and get the employee to actually sign something to confirm that they have received it. But not this particular company who we're talking about.
No, and of course they employ a lot of people whose first language is not English.
Yeah.
And how would you? I mean, you've experienced this now for 5 years or so. How could a legal aid system be operated to be for such people, litigants who are representing themselves, don't understand, haven't got a clue about what's happening? How could you have a legal aid system to be effective?
Well, the judiciary are supposed to take that into account, that they're dealing with someone who's not legally qualified.
Right.
And likewise with employers who represent themselves, and assist the parties as far as possible they can to make their case and then make a decision. But when it gets to lawyers being involved, particularly on both sides, then it's royal court rules, and it becomes pretty brutal.
Well, yes, I mean, there are aspects like disability discrimination, which are all worked in. Somebody who has got an injury or an impairment, and the employer knows about it, maybe he doesn't know about it, whatever the circumstances. But the legal interpretation of all these things, they become paramount, don't they? They become, it's like you either win or lose your case.
It's very, very technical.
Yes.
The September 2018, the protected characteristic of disability comes in. It changes the way that employment tribunals operate. And the
adaptations. What is the reason why I'm saying disability is? I've been campaigning about disability issues for many
and of
years.
course, what we've discovered, there's a deficiency in the law and the way it's drafted. It's not as generous as it is in the UK, just for the slip of the law draftsman's pen. Now, whether that was deliberate or whether it was an accident, we don't know. But it's something that needs to be changed.
Have you ever heard of or have you noticed a disability campaign group here representing somebody or assisting a claimant? Have you ever noticed that? No,
never. We know in Guernsey there's quite an active lobby there, and they were brought in, campaigned for much more principled legislation, whereas Jersey has followed basically the UK with ameliorations.
Right.
It's got a much lower bar.
I know. You were arguing the other day or discussing effective date of termination, and I was listening to this what they call effective
EDT.
EDT. They say, what's the EDT? Well, as though everybody knew what an EDT was. Effective. Well, you think that's simple, wouldn't you? The day somebody finished work, but it's not that simple, is it?
No, there's lots. Well, they haven't quite decided what it is in the UK. It's much disputed. And it's not entirely, it hasn't been fleshed out in Jersey in the decisions. I mean, it's there, but it's not fully discussed because of the way that judgments get presented. In one of my most recent cases, I really argued it very strongly, what was effective date of termination in terms of English law, but there was pushback to it from the other side, particularly using Jersey common law precedent. I mean, my goodness.
Absolutely. I mean, they can go back to Normandy and dig up any old stuff, can't they? Who the hell knows their Norman law? But this is another thing.
This is just to muddy the waters.
Absolutely.
Yeah.
I mean, you raise English precedents, and they say, well, we're not doing English precedents today. We have to have Jersey law. They play the Jersey flag, don't they? They do that and say, well, we're not having it. But they do. They quote English precedents all the time.
They are, but they're supposedly persuasive but not binding. But, of course, they are followed, but when it suits.
Well, how the litigant in person, the sacked person is supposed to know that if they try to...
And a lot of even representatives from the UK who are coming have to and can be tripped up by the fact that the law in Jersey is not the same as in the UK, and they can make errors.
With regard to the legal aid, do you think perhaps something could be inserted at the JACS stage? Do you think that could be more of a legal aid service? Is that a possibility?
Well, I don't think it's going to happen. I mean, it's legal aid.
How does it happen in the
deficient.
UK? What happens in the UK? I mean, how do people get represented there?
Well, there are all sorts of pro bono organisations that will assist, particularly when you go to the Employment Appeal Tribunal. It is possible, but it's tough. And there are lots of just unqualified representatives of various skills and various abilities, and this has posed a challenge to the judiciary, because they've now got a new set of, they've got solicitors, they've got barristers, suddenly they've got all these representatives who they are wary of because of their levels of competence. That doesn't really exist in Jersey as yet. There are no, I mean, the only person who does represent.
There are grumblings about it, aren't they? They sort of, I mean, as you were an English solicitor, but I've represented people on occasion, mostly Social Security, and they're sort of, well, a Mackenzie man, or you're advising, all this sort of stuff. Your status is very insecure, and they're asking if you're helping. Are you insured? Am I insured as a layperson? Well, obviously, I'm Fred down the road. I'm a help. I'm just a friend trying to help. Are you insured?
Well, the tribunal had to amend the form, and I take credit for that. They actually changed it. They had to put a section about, are you? What were the two parts? There's two parts in the form. Whether your representative has indemnity insurance. And whether they're going to receive any kind of remuneration or fee from representing.
Of course, the other side, if they've got lawyers represent, of course they get paid, don't they?
Absolutely.
Nobody asks that question.
No one asks whether it's £350 or £500.
But somehow or other, it's unseemly for the litigant in person to have a friend who's.
That's the problem that employees face.
Yeah.
That they're handicapped with one hand behind their back. In fact, sometimes twice.
And most employers have got an insurance they can call on, so that most of them can employ a lawyer.
Many of them do have that form of insurance, and it's not uncommon.
Is the system as it operates now, is it capable of being fair to the litigant, the person who's lost their job for whatever reason? Is it capable, do you think?
Well, the problem is Jersey is the kind of, everything is the light version. It's the Potemkin village. It's where the appearance of fairness, equality, and is there. The answer is sometimes. Sometimes there's some amazing decisions where litigants in person, particularly in racial discrimination areas, which is very difficult, complex, will succeed, and clearly the judge was very favourable to them. Oftentimes, particularly where there's an advocate on the other side, they can really throw the whole case and skew it in the favour of the employer, and the court's not paying too much attention to the employee.
Of course, the UK obviously is going to have a bigger a larger number of discrimination cases they've dealt with over the years arising for whatever reason. So they will have precedents there which they can call on. And obviously, even in the UK, the current campaigns that have been going on, black and white and all the rest of it, there's a lot of development going on. But the worst aspects of that discussion isn't the demonstrations aren't taking place in Jersey, so it's not being tested in the same way as it. The UK is much more testing of the elements of discrimination, isn't it? They just had a report came out in the UK which was trying to suggest there's hardly exists at all, or something like that. But certainly there is discrimination here within the community, which is fairly. What do you do about it? If it spreads into the workplace and somebody is called offensive.
Well, we could ask the states members to amend the discrimination law, so at least it's on a par with the UK in terms of the time limits and the extension of those time limits. But I don't think many states members would be interested in it.
No.
It's been drafted by bureaucrats, and there it remains. And it's not going to be reformed.
I suppose if states members could complain unfair dismissal if they lost their seat in the election, that would rather waken things up a bit, wouldn't it?
Somehow I think not.
Anything else you want to tell me? We better stop.
Well, this is the useful introduction. I hope we can do some other videos, and we'll talk about some specific aspects. There certainly needs to be something like this on YouTube or wherever to guide people through, because there's nothing to look at to work out what it is you're supposed to do, what your rights are, where you go. This could be a series.
Ironically, I'm reminded that many years ago, the current bailiff, when he was a mere advocate, used to appear on the BBC radio, giving updates on the current legal trends. He used to do that on the radio for those who got up early enough. And I did speak to him about it one day when he shortly after his appointment as bailiff, if he thought such a thing was a good idea, and he was a bit non-committal, as you might expect.
One of the things that's missing is the large firms of advocates don't seem to want to deploy their junior staff to do these kind of employment tribunals, because it's a great way of improving advocacy skills. But obviously chargeable hours are much more important than training up their staff, but it would be a really good way and relative, because it's flexible, the employment tribunal, and it would get them up to speed on litigation very quickly, I think. But hopefully we'll see that. But it has been mentioned by previous chairs of the tribunal, yes, but not acted upon.
Well, perhaps we can create a little blog which does specifically deal with employment. Maybe we can do that.
Yeah, it's needed.
Okay, thanks, Nick.